Yeah, I'll be starting in 2 minutes. Let me do the settings. So yesterday we did the latest enactment of Evidence Act. So today I'll be starting with the new bill of Indian Penal Code as well as CRPC. So when I talk about new bills, you should remember that why these bills are being introduced. The reason is very simple. I told you in my earlier lecture that most of these acts, Indian Evidence Act, CRPC, even your CPC, they are of 18th century. So 18th century, we are now in 21st century. So most of these laws uh, they needed change and they were made by the Britishers. So today we'll be discussing what are the new changes in the new acts. See, as you remember, I have been telling you again and again that these laws need to change with the passage of time also, right? So if the and who changes the law in our country? In our country, the law is being changed by the parliament, right? So you should know what is a lower house, you should know what is a upper house. So now first start with the new IPC. So the new IPC is now known by the name of, yes, it is known by the name of Bharatiya. I can write down on the chat box for, I think it will be convenient for you. The new name of IPC is Bharatiya Bharatiya Nyaya Samhita. Now this is of 2023. All right. So when I talk about IPC, you all know that IPC talks about the various principles. So when we read IPC otherwise, we start with actus rea, with mens rea. These are the two components of IPC because presence of these are mandatory to make an offense live. But there is exception also in IPC because there is general exceptions in IPC where there is no liability on the part of the um accused because these are provided by the way of general exceptions. So coming back to the latest Indian Penal Code, so you should remember that IPC basically talks about the principal law on criminal offences. So when I talk about IPC, you should know there are different category of offences. There are offences which are affecting the human body. What are the examples for it? For it, assault is an example, murder is an example. Then there are offences against property. So, like extortion, theft. What are these? These are examples against the property. And then we have also offences against public disorder. So they are what are the offences against public? One of the very famous category of offences is unlawful assembly, right? Then also you should not forget about rioting. It is also one of the offences against public order. Then we talk about public health, safety. So we talk about grievous from aggravated form of robbery, which is known as dacoity, right? So morality and religion, they are also the offences which are against the public order. And then we have offences against defamation. So defamation offense is also one of the category of offences. And last not the least are offences against the state. So this new bill, it definitely retains several parts of IPC, but what are the changes you have to bear in mind? So I'm giving you a brief outlook of the changes. So changes include introduction of offenses of organized crime. What are the organized crimes? Like terrorism. So it also talks about enhancement of penalties for certain existing offenses and introduction of community service as a as a punishment for petty offenses. Now, this is very important because if you are a student of criminal law and if you know about criminology, always remember that there are different ways by which the punishment can be done. So retribution is one of the main important factors while deciding a punishment. So for petty offenses, what has been done now? So for petty offenses, they have they have introduced the um, uh, community service as a way of punishment. So moving moving further, uh, we talk about uh, other forms of offenses. So moving further, we also talk about introduction of community service. I have told you. So there are certain offences under IPC which have been struck down or read down by the courts have been omitted. So what are these offences? Like adultery. Adultery, it was uh, taken out. So now this is no, it's not an offence in Indian Penal Code, right? And also there are offences of Section 377, right? So they have also being taken out of the IPC. That is the same section to course 377. So these are so here when I talk about these things, you should also know about the rights of LGBTQ, right? So here in this lecture, I'll be also talking about the latest. What is the view of the courts into this LGBTQ cases? So let me discuss on that because this is one of the important issues these days, which is being discussed in almost all spheres of society. And this is very important point. This is very important legal knowledge because when you talk about law, you should also update yourself with the latest enactments and also about the latest developments which are being developing around you. So when I talk about these, so I'll be now I'll be giving you some inputs on that. So when I talk about LGBTQ, so LGBTQ, so what do you mean by LGBTQ? So LGBTQ is a community of India, right? It has been struggling their rights as a citizen of India since its independence. Okay? So if you remember, there was a very famous case of Supreme Court way back in 2018, and that the name of the case was Navtej Johar. What was the name of the case? Navtej Johar. So when I talk about case of Navtej Johar, this is one of the landmark cases when we talk about LGBTQ. So here you should remember that the Supreme Court of India held the right to equal citizenship to the community representing LGBTQ. So LGBTQ, so the Supreme Court held that section 377. So what is section 377? Yes, Shivani, read section 377 of Indian Penal Code. Yes. Yeah. So read 377 Bhavna of Indian Penal Code. So what is 377? Open up your Bear Act. Yes, read 377.
Reading, sir, 1 minute.
Hmm.
Unnatural offenses. Whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment of life or with imprisonment of either description for an term which may extend to 10 years and shall also be liable to fine.
All right. So you read the explanation on your own. So you see, this 377 is now no more part of the IPC. So why I am focusing on 377? Because I also conducted an interview in one of the judicial academies, and they just honored me on the last week. So this is a very general question also, and this is a legal topic also, because lot of hue and cry is there. There has been judgment, there is being arguments in the Honorable Supreme Court also, that the rights for LBGTQ, right? So basically, it is lesbian and gay rights they're talking about. So here, they say that we should also be given equal representation in the society, and that is why effect of this was that Parliament has omitted this offense from the new penal code. So I will say this is one of the major achievements for people who support LGBTQ rights. So this is a very important topic for you, because I think this is one of the hot topics, and lot of news when you read the papers also, the legal journals also, this is being circulated, and you should be aware of it. So as I told you that whenever I talk about this rights, you should always remember the case of Navtej Johar, right? So this is 2018. You want me to write down the case in the chat box? I can write down for you. So it is. So let me share my experience with the candidates who are appearing for the mains this time in Punjab. So majority of the candidates were spending almost, they never had any practical experience, and they've been that is why most of them were lacking on the interview side. So what I could guess out was practice is very important. They were lacking basic knowledge. They were having very good scores in the studies, but when I was asking them the practical questions, they were like, they had no idea. They were making a lot of errors, because when you are supposed to be a civil judge, junior division, or a magistrate on the preliminary stages, you should know how the process will start. So that is why, there is a landmark judgment of Supreme Court which says that 3 years mandatory training is important, and that is up to the state. But our state, Punjab and Haryana High Court, has opted for 1 year intensive training in the Judicial Academy, and then they take the exams. So those exams, they're the toughest of all, right? So the candidates who clear those exams, they are only sent ahead. Otherwise, you are demoted, and probation पर वो आपको फिर they send you back also. So this is one of the important cases. Navtej Johar, Navtej Johar versus Union of India. Now this is a 2018 Supreme Court case. So this is very important case. So here what happened? In this case, the Supreme Court of India upheld the right to equal citizenship to the community representing the LGBTQ rights. Okay. So Section 377 of Indian Penal Code that read that consensual relation between adults of the same sex or otherwise as a criminal act was held unconstitutional. So देखो ये 377 unconstitutional किसने, who has held it to be unconstitutional? Supreme Court. उसका after effect हुआ कि Parliament changed, made a new law, and they have omitted this because it was already declared unconstitutional. So here I can say that Supreme Court exercised its judicial review powers, and they held. So there's also called judicial activism, right? So this is one of the main essay topics for you also. So you know, so these are very important, uh, you know, transformations which are taking around, and you all are aware. You all should aware about it. अब आप देखो, आपको ये नहीं पता होगा लॉन्ग लिस्ट ऑफ इंडिया कौन है आज की डेट में. So you should know the newspaper. If you're focusing something in Punjab, you should know who's the law, who's dealing with the Department of Law, law minister कौन है Punjab. So these are the basic things which you should be aware of. So moving further, so the court also recognized that the yoga karta principle. So what is a yoga karta principle? So yoga karta principle, basically it talks about these are the principles which have been described, and it talks basically there are certain principles of the ancient yoga which were being followed by different sects of society. So the court recognized the yoga karta principle. So when I talk about this, so there is a famous commentary on this by M. Carpenter, right? So it talks about yeah, just mute the off kar lo video, brother. So here the court recognized the yoga karta's principle to which India is a signatory. Video off kar lo, Jaimal ji. Section 377 does not conform to India's internet. Video off karo ji, video off. जयमल जी वीडियो ऑफ करो अपना. हाँ जी ठीक है, कोई गल. ते म्यूट भी कर लो ब्रदर, म्यूट भी कर लो अपना ऑडियो जेड़ा हैगा म्यूट करो. बेटा अपना ਤੁਸੀਂ ਨਾ ਵੀਡੀਓ ਵੀ ਬ੍ਰਦਰ ਕਰੋ ਮਿਊਟ, ਮੈਨੂੰ ਡਿਸਟਰਬੈਂਸ ਆ ਰਹੀ ਹੈ. ਜਾਨੀ ਨੇ ਦੱਸਿਆ ਵੇਖ ਲਓ ਤੇ ਇਹਨੇ ਤਾਂ ਜੇ ਤੱਕ ਨਹੀਂ ਦੱਸਿਆ ਵੇਖ ਲਓ ਇਹਦਾ ਰਤਾ ਹੀ ਵੀ ਇੱਕ ਮੁੱਕੇ ਲੱਗੇ ਆ ਜਦ ਪੰਪਿਆ ਉਹਨਾਂ ਦੇ ਘਰ. ਤੁਸੀਂ ਆਪਣਾ ਆਡੀਓ ਮਿਊਟ ਕਰੋ. ਜਲੰਧਰ ਐਸਐਸਪੀ ਡਾਇਰੈਕਟਰ ਦਾ ਡੀਐਸਪੀ ਡਾਇਰੈਕਟਰ ਕਰਤੀ ਉਹਦਾ ਭਤੀਆ ਵਾ ਮੁੰਡਾ. ਸਾਰੇ ਭਰਾ ਉਹਦਾ ਭਰਾ ਵੀ ਆਡੀਓ ਬੰਦ ਕਰੋ ਆਪਣਾ. ਪਰਿਵਾਰ ਵਧੀਆ. ਲੈਟ ਮੀ ਤੇ ਦੱਸ ਇੱਕ ਮੇਰਾ ਨਾ ਦਿਮਾਗ ਸੌਰੀ. ਹਾਂਜੀ I think I can also mute it from the yeah. So how can I mute Bhavna? Tell me from. Okay.
Sir, if you are the host, you can mute them.
I can mute
settings में option. हाँ जी.
ओ भाई की बोली ਜਾਂਦਾ ਸੀ ਮੈਨੂੰ. एक second, like you are there na, so I can okay yeah, yes. I can mute you, right. ठीक है fair enough. Anyway, so okay, yeah, so yeah, so my view is clear.
Yes sir.
So where were we? We were at section 377. So basically I've told you about this yoga karta principle also. And so moving further on this discussion, you should remember that same-sex marriage is still not recognized in India because the community faces different problems related to civil rights. So most of the laws pertaining to civil rights do not include them, and they are based on person's marital status. So Bhavna, you should be aware that there is already a lot of litigations going on in the Supreme Court, and I don't think anything has came concrete in it. Yes or no?
Yes sir.
Yeah, I don't think Supreme Court has recognized our country has recognized anything on LGBT. So
Still not.
yeah. So, but it is a very important topic, and so Supreme Court has not. Our society hasn't declared it to be valid, and so you should remember that the Supreme Court has reserved the verdict, I guess. अभी तक इस पर कुछ आया नहीं है. I don't think they have come out on anything on that. So, so they've not recognized it as of now. So coming back to this, yeah. So coming back to on this, uh, you should also remember that you should know that if you look at the changes brought or proposed related to adoption and surrogacy, they have also failed to incorporate the rights of LGBTQ community. So you should be aware of rights of about concept of adoption. Nowadays, this inter-country adoption is also one of the important topics, and you should know what are the different facets of it. And then we talk about surrogacy also. So surrogacy rights also are very, very important. And moving further on this, just hold on. Just give me- let me take a call. Yeah. So yeah. So you should also remember that there is CARA, CARA, that is the uh, Central Adoption Resource Authority. So it's a government of India's statutory entity, and under the Ministry of Women, under the Ministry of Women, so and Child Development. So it serves as the main organization for individual. So it serves the main. So it serves the main purpose, and this authority. So prima facie, it serves the main organization for Indian child adoption and oversees as well as regulates the domestic and international adoptions. So the statutory body of the government is CARA, CARA. We call it Central Adoption Resource Authority. So, so as per the guidelines and regulations issued by that authority, even intersexual couples in a live-in relationship are also not allowed to adopt. So these legislations only reinforce the stigma against LGBTQ community, which Article 377 wants to obliterate, right? So you should remember it. Moving further, moving further on this, let's talk about LGBTQ only. That what like we talk about parenthood beyond marital relationship. So when I talk about parenthood beyond marital relationship, you should remember that the ideal family in society consists of a couple, right? So heterosexual, of course, with the possibility to bear a child and upbringing this child according to society's norm. This is the culmination of marriage, right? So the basic idea of having a child and desire of parenthood is related to the biological process of giving birth to children. That is why we say this is act of God. Nature plays a very important role. So the parents' rights and obligations are based on the genetic contribution, where the wife has to be the bearer of the gametes of two parents. This is the fundamental nature of parenthood based on the biology of reproduction. But you should not forget that if we see beyond natural ways of parenthood, a person's desire to become a parent can have other possible ways. What is that? Surrogacy and adoption. So, in today's time, the state has come up with other possibilities to be a parent. So, in India, Hindus can only adopt. So, when I talk about Hindu law, when we will be doing this adoption, you will come to know that only in Hindu Adoption and Maintenance Act 1956, Hindus can only adopt a child legally according to Hindu Adoption and Maintenance Act, right? So people belonging to other religions who want to adopt the child can only take the child as a guardian. Where it is mentioned in Guardians and Wards Act of 1890. And this is a very important aspect which I have just told you. So there is one another statute which talks about the children especially. that is called Juvenile Justice Care and Protection Act of 2000. Now, this is also very, very important topics. You should know about it. Juvenile Justice Care and Protection. What is it? It intends to be secular and applies universally to the single parent desiring the adoption of a child in need of care and protection. So, unlike the Guardians and Wards Act 1890, this statute establishes a relationship between parent and child and is not merely limited to guardians. So, this legislation aims the care, protection, development, and rehabilitation of a child who has been abandoned or is an orphan. So, this is a very famous judgment where this part was where this you say ratio descendi was laid down. So what is ratio descendi? That is the law which is laid down in the Supreme Court judgment. And what is opta dicta? That is the observation. So here I will also mention you the name of the judgment which I am relying on, and that is Shabnam Handa, Shabnam Handa versus Union of India. Now this is again a 2014 Supreme Court case. So moving further, so when people want a biological child to enjoy parenthood, then they can opt for surrogacy. So the best example is who's the best example? Famous, the Shah Rukh Khan's third son is by way of surrogacy. Do you know this? Yes. And even Karan Johar's children are by way of surrogacy. So these all developments are very, very important, and you should be aware of it. So I think this is enough for LGBTQ because I have told you that these are the important uh, aspects when we talk about LGBTQ rights. But you should also remember few more important cases in this I will be mentioning. So you can write down the case name. So when I talk about this case name is the famous case of 2017. The case name is JS Tuswami. So this is JS Swami versus Union of India. Now this is a 2070 Supreme Court case. Okay. So, so this case dealt with detailed analysis of person's autonomy, right to choose, and privacy. So the Supreme Court unanimously ruled that right to privacy is a fundamental. Every person has the right to choose their way of living, which could not be interfered with by the state without any necessity. Now, right of privacy, my right of privacy, you guys' right of privacy, it's a very, very personal thing. Nobody in the world can interfere in it, right? You want to go to the court, you want to attend the court and then come back in the library or in the chamber and read. That is your right. You don't want anybody on that, absolutely fine. So this is what I say. Who definition of happy human being is the person who has balance in life. And I say the right to privacy, nobody wants it to be infringed. Whatever relationship you are in, maybe it is husband, wife, maybe it is mother, parents, children, everybody wants their privacy. Nobody will want to you to peep into somebody's life. Doesn't mean even if you have a relationship or you are married or you are brother, sister, or you are family. So right to privacy is your own personal domain and it is being protected by Article 21. And it's a fundamental, it's one of the main fundamentals of life. So Here the Supreme Court unanimously held. So when I say Supreme Court unanimously held, it means all the judges agreed in this part. So in Supreme Court, you should all remember there is never a single bench. There are always a division bench. Then there is a full bench consisting of three judges. And then we have a constitution bench of five or five or more than five. So full bench is three till four, three, even four judges, so full bench, constitution bench, right? So nowadays the constitution bench, which is in use where Article 370 has been reserved, is consisting of how many judges? This is your mother. And you will find it out how many judges were there. Yeah, we all know Chief Justice Honorable Mr. Chandrachud was there, but we also had Honorable Justice Surya Kant. And what is the name of other judges? And what is this bench called? So this you find it out and you let me know. Let me now quench a glass of water. Just give me a minute. So moving further, yeah. Sorry, I had an important call to attend. Yeah. So moving further, you should know about yeah. So privacy of a individual is an essential part of dignity. So dignity has both an intrinsic and instrumental value. So when I talk about human dignity, so it says as instinctive value, human dignity is an entitlement or a constitutionally protected interest in itself. So in its instrumental fact, face it, dignity and freedom are inseparably intertwined, each being a facilitative tool to achieve the other. So the family, marriage, procreation, and sexual orientation are all integral to the dignity of the individual. It means, what does it say? It says no means no. So here I also talk about Article 14, 19, and 21, forming the golden triangle. So golden triangle, you should remember what is the golden triangle? Article 14, 19, 21 gives the person to form an association of her choice and exercise his autonomy. So the concept of self-perceived identity can be understood as a facet of normal authority. The normative authority means the individual has control over the things she considers necessary in life. It can be a choice to marry, procreate, decide on a partner, and have a family. Any state action must not obstruct such autonomy unless there is reason to do. This was held in this judgment of one of the most important judgments. I'll be just mentioning, that is, I have just mentioned the earlier judgment, and that was so here the judgment which I'm talking is about this one. I've just given you the judgment of yeah. This is, you can write down the judgment name. This is uh, Shabnam Hashmi versus Union of India's judgment. So, so these are the important factors when I talk about LGBTQ community. I can elaborate. I've already elaborated much on this, and you can just go through it, and I think that will serve the purpose. Whatever the new judgments and whatever is the new enactments, if so comes in its progress to getting it as a recognized right. So I'll share it as and when needed. Now let's come back to the IPC, which we were originally discussing. So we were basically talking about yeah. So the 377 we have discussed. Now coming back, yeah. So now coming back to after 377, you should also know what are the key changes. So key changes in the new act includes sedition. So sedition, IPC defines sedition as bringing or attempting to bring hatred or contempt or existing disaffection towards the government. Like you say, you hate the central government, there is a hatred, you are trying. So, this sedition was being used, is normally being used by, especially by the state or central government, or, the government who is in the power in a state to book people for their voice against it. So this is being misused also, and a lot of controversies are being created when we talk about sedition, right? So sedition, so I've told you what sedition is. Sedition means it is so sedition is as bringing or attempting to bring hatred or contempt or existing disaffection towards the government. It is punishable with, now see the penal. So always remember, when we file an FIR, there is an FIR in a case. Always remember the offences of IPC which are written in the FIR is always the punishment offences. You never write murder, you all write punishment for murder, right? So whenever you see an FIR, it always describes the punishment section. So, so when I talk about accommodation punishment, it is punishable. Yeah, this is punishment. It is a so the punishment may includes, and this is between 3 years and life imprisonment or a fine. Imagine, life imprisonment is also there in sedition. So this bill removes the offense. It instead, this is very important change. So it removes this offense. It instead penalizes the following. What it penalizes? First, existing or attempting to cite secession, armed rebellion, or subversive activities. Second category, it says encouraging feelings of separate activists, Kattarbanti, right? Or third, endangering sovereignty or unity and integrity of it. So we see in preamble, we see where this India is sovereign. So when it is endangering the sovereignty or unity and integrity of India, so this also comes into foreplay. So these offenses may involve exchange of words or signs, elements endangering sovereignty, so electric communication and use of financial means. जैसे कट्टरपंथियों को जी बाहर NRI ने स्पॉन्सर किया, ठीक है. This is also, so this will be punishable with imprisonment up to 7 years or life. Earlier it was 7 years and life imprisonment. Now it is up to 7 years or life imprisonment or and. So this is one of the radical changes which was, but I still think this a life imprisonment punishment is unjustified in this act. This should not be the case. तभी तो देखो ना हमारे इतने क्रांतिकारी हुए हैं, है ना? We see lot of people were jailed, lot of, why the sedition was the main devil against. So the Britishers drafted it this way कि नहीं जी, हुकूमत के आगे आवाज निकालोगे तो इसको जी काले पानी में भेज दो, बेचारे उत्थे मर गए, you know, and lot of the highest people of the state who have sacrificed for freedom are the Punjabis. Okay? So Punjabis include everybody, Hindus, Sikhs, Muslims, so all Punjabis have sacrificed their life, and हमें ऐसे नहीं freedom मिला. But unfortunately, we're still following the colonial era. I think this imprisonment of life in sedition is unjustified. It is not called for. It is one of the reflections that we are still being governed by the colonial. Okay. So then I've moved further about other changes in the IPC. That is the terrorism. So the bill defines terrorism as an act that intends to threaten any unity, integrity, and security of the country. So पहले TADA होता था, TADA, right? Now in IPC they have defined the meaning of terrorism also. So this bill defines terrorism as an act that intends to threaten the unity, integrity, and security of the country, to intimidate the general public, or disturb the public. So terrorist act includes, what should it include? Using firearms, bombs, hazardous substances, biological or chemical, or cause death to life, spread a message of fear. It also means destroying. It also means destroying property. So destroying property or disrupting essential services. Activities included in the treaties listed in second schedule of unlawful activities, Prevention Act 1967, such as unlawful seizure of aircraft or taking hostages, punishment for attempting or committing terrorism, including death or life imprisonment, where the offense has resulted in the death of any person. Imprisonment term between 5 years and life in other cases. An offender will also be liable to a fine of at least 5 lakh rupees. So the bill also uh, punishes, criminalizes conspiracy. So what is a criminal conspiracy we will do when we will be starting IPC? It also talks about organizing or assisting in preparation of any terrorist act with an imprisonment between 5 years and life imprisonment, and fine of at least 5 years. So this is how they have included the definition of terrorism in IPC. And moving further, we talk about the organized crimes. So organized crimes, the bill defines organized. They have also the new definition of organized crime is also included in new IPC, that is Bharatiya Nyaya Sanhita 2023. So the bill defines organized crime as a continuing unlawful activity such as kidnapping, extortion, contract killing, land grabbing, financial scams, and cyber crimes. I repeat, cyber crimes is also included in organized crime. And then it says carried out by use of violences, intimidation, or other unlawful means. Next, to obtain material or financial benefit carried out by individuals acting singly or jointly as members or on behalf of crime syndicate, attempting or committing organized crime will be punished with death or life imprisonment, where the offense results in death of any person, and imprisonment between 5 years and life in other cases. The offender will also be liable to pay a fine. Moving further, we talk about petty organized crimes. So this new bill makes attempting or committing petty organized crimes punishable with imprisonment between 1 and 7 years and a fine. Petty organized crimes are those which cause general feelings of insecurity among citizens and are committed by organized criminal groups, gangs. These include organized pickpocketing, snatching, and theft. I repeat, these include organized pickpocketing, snatching, and the theft. Moving further, murder by a group of persons on ground of caste or race. So bill specifies separate penalty for murder committed by 5 or more people on specific grounds. These include race, caste, sex, place of birth, language, or personal belief. Each offender will be punishable with imprisonment between 7 years and life or death. It will also attract fine. So these, same caste marriage in Haryana, Khap panchayats, one of the examples of it. Then moving further, death penalty for gang rape of minor. So IPC allows death penalty for gang rape of women below 12 years of age. The bill allows death penalty for gang rape of women below 18 years of age. Now there is a death penalty. It comes under rare of the rare cases. So next important point is sexual manner by deceitful means. The bill penalizes the act of sexual intercourse with a woman not amounting to rape through deceitful means or a promise of marriage without intending to fulfill it. it will be punished with simple or rigorous imprisonment up to 10 years of. So this has been, this is also now a important change in the new IPC, that the bill penalizes the actor. So, and the last important change which is there is extending applicability of certain offences of to boys. So under the IPC, importing girls under the age of 21 years for illicit intercourse with another person is an offence. The bill specifies that importing boys under the age of 18 years for illicit intercourse with another person will also be an offence. So all this kuputribazi and illegal activities to be curbed down by the amendments and the new bills of Indian Penal Code. So this is regarding Bharatiya Nyaya Sanhita, sorry, okay? That is the IPC. Now let us talk about. Now we talk about the others. Now to move further is to this one. Now we talk about Criminal Procedure Code. So we talk about the Bharatiya Nagrik Suraksha Sanhita. So again, it was introduced on August 11th, 2023. It repeals the Code of Criminal Procedure Act 1973. So the code provides for procedure, arrest, prosecution, and bail for offences under various acts, including the Indian Penal Code 1860. The bill retains most of the provisions of the code. Key changes proposed under the bill include: first is detention of under trial. So under trial prisoners is also one of the legal topics, because we see a lot of under trial prisoners out there where they have spent more than the double years of punishment than which was originally prescribed. So here also the delay is one of the reasons, and that is why the court feel fit to introduce this detention of under trials. So I think for today we will wind up the session on this, and we will uh, further continue. Okay, is it clear?
Yes.
So yeah, sure. ठीक है बेटा.